All right. Please be seated.
Good afternoon. My name is Mary Nardella. I am presiding today on the bench as well as Judge Ganem and Judge Mize. We're here for an afternoon session of the oral argument for the Sixth District Court of Appeal. I know both counsels have appeared before this court before. As you know, each side is given 20 minutes to make their presentation. Counsel for the appellant, you have 20 minutes. As you know, you may reserve time for rebuttal. We typically reserve 5 minutes, but if you would like an additional increment of time, please let us know.
5 minutes, please.
Whenever you're ready, counsel.
May it please the court. My name is Nick Shanine, and I'm here representing the appellants in this matter, Mr. Nishad Khan and his law firm, Nishad Khan PL. This is a matter of a joint venture that started an LLC to buy one piece of property. That piece of property grew greatly in value, but rather than sell the property and split the proceeds, or rather than dissolve the property and amicably or equitably split the proceeds, everything went wrong. And one partner decided to take ultra vires actions against the other partner, attempted to expel him. And then while he was attempting to expel him, tried to evict him and tried to sue him. All of these actions were before the lower court in 3 different successor judges. Through those permutations, a final judgment came to be. That final judgment, unfortunately, contains no tangible findings of fact that help this court or these appellants.
Required to include any findings of fact that it didn't include?
It is required to show its map. It's not required to, it's not a family law case where there's a statute that says thou must have these 12 findings of fact. That's not required.
What's the authority that the trial court has to show its map?
But there's longstanding authority that this court insists that a trial court provide it with that which it's necessary for meaningful review.
There's
The-
longstanding authority from this court on that?
Well, this court, of course, doesn't have longstanding authority because of its recent creation, but back to 1988, we've cited the Saversfield Savings and Loan case for what I would consider, very reasonable and well-established principle that a trial judge, even where a trial judge has discretion, can't be arbitrary in the application of discretion. They
Can't be arbitrary is different from must show work.
Well, and that's correct, Your Honor. My point being that if you're going to come up with numbers, and those numbers are not the numbers that either side specifically proposed, and they're not numbers that otherwise are intrinsically obvious from documents that were presented to the trial court, it becomes a fortiori arbitrary to just have these numbers appear unless some level of explanation is given. And in this case, rehearing was specifically sought on that exact point. Dear Judge, please provide it.
So it's not that there's any law saying the trial judge must show his math. It's that the trial judge must not be arbitrary.
That is correct, Your Honor.
And you think if he doesn't show his math, by definition, it's arbitrary.
In a case where there is not intrinsic and self-evident basis for that math, then yes, Your Honor,
So
that's exactly right.
So the proper view of it's not, is there any view of the evidence that could have supported this math? It's, you must show the math.
Well, in order to go to any view of the evidence theorem, that we can't know what evidence we're supposed to be looking at because we don't have the initial findings that we would need to be able to do that. That's why this court and other courts have said that we need to have sufficient findings. And courts have thrown it back to the lower court to, at an absolute minimum, provide those findings. This court has done that on attorney's fees matters. This court has done that on other matters. This particular scenario may not have yet fallen before the court, but that would be the reason why it cannot be that you can't pluck numbers out of the air and throw them on
Well, but
paper.
that kind of presupposes the trial court picked them out of the air as opposed to taking them from some reasonable view of the evidence and just not explaining them, right? I mean, say there are 12 different ways you could look at the evidence, right?
Sure.
And 10 of those support the trial court's ruling. Trial court doesn't tell us which one. But we know there were a multitude of ways the trial court could have looked at it that made the trial court's view of the evidence, ruling reasonable, or within its discretion. Is it still arbitrary just because he didn't explain which of the 10 he chose?
Well, I would first say yes, because if you're picking a random number that wasn't supplied by a party and wasn't supplied directly by the evidence, it's still arbitrary. However, in your hypothetical, you established it that 88% of the possible scenarios came up with these numbers. If that's the case, then certainly a reasonable argument could be made that even though it's still arbitrary on paper, it's not in reality. Here, however, these numbers are not. There's not 12 possibilities. There's perhaps a million permutations.
That seems to be kind of conceding that unexplained does not necessarily mean arbitrary, right? I mean, unexplained means unexplained,
And
and
I
that might be arbitrary, it might not. And that just seems to me to be two different issues.
And I would argue that they are still intrinsically tied issues, that the failure to give findings combined with the failure to have intrinsic or self-evident basis for that math. If it's a physics problem and we know what gravity is, we know what the constant is, we know what the weight of the object is, and the question was, at what speed was it when it hit the floor? Even if you don't show your math, you might get knocked off by your physics professor, but you won't get knocked off in the law because we can adduce that with certainty. Here, not only can we not adduce anything with certainty, we have absolutely no idea. Were holdover rents applied? Well, we would suspect they must have been in order to get a number that big, but we don't know when those holdover rents started. We don't know when those holdover rents ended. We don't know the justification for why you would do holdover rents in an instance where it's ultra vires to start with and you can't have holdover rents. We don't know whether there were any credits given to what Nishad Khan had donated or put into the business going into it. We don't know what the established theoretical rate of rent was.
To write an opinion in your favor, do we have to say that if you don't make findings in a bench trial, the ruling's arbitrary?
I would say your decision would not need to go quite so far, but it would need to say that in this instance, the judge failed to provide sufficient findings of fact to allow us to deem the numbers generated anything other than arbitrary.
And how will we decide, how do we describe this instance as one that required findings as opposed to other instances that don't?
Again, I don't believe you would have to define that in this case, Your Honor. I think you could simply state in this case, the judge failed to do so. And then the facts that you provide within the opinion will allow.
So this case kind of just a know it when I see it kind of thing. Like this case just needed some findings. It's sufficiently, fuzzy.
Answer is this case did need some findings, and the appellant begged for those findings and didn't get it.
Can you give me a description of this, the attributes of this case that made it require findings as opposed to a case that wouldn't require findings? Assume I want to explain it if we write an opinion.
And I appreciate that, Your Honor. In the instance of a final judgment where numbers are to be determined and those numbers are not self-evident or the numbers that were specifically requested by either party, findings must be present sufficient to allow a reviewing court to know the judicial basis for arriving at those numbers. I think that would be a perfectly reasonable summation of legal constructs that have existed from time immemorial, just perhaps not synthesized because this doesn't happen.
So no other Florida court has synthesized that rule yet.
I am not aware of that. I'm clearly aware of cases where they have said findings of fact were necessary in this case. I'm also clearly aware of cases where arbitrary decisions of a trial court can't be upheld because if it's arbitrary, by definition, you have failed to do that which is the judicial role. The judicial role requires something completely opposite of arbitrary. It can be wrong, but it needs to be with a reason. If it's wrong, that allows this reviewing court a much better stance with which to make its rulings.
So you're saying that courts have said there is a line after which or beyond which findings are required, but none of them have defined the line yet. They just kind of said, this case is on the other side of the line.
I'm going to answer that. Yes, that's exactly
I appreciate the
what
answer.
cases do.
So you want us to, sounds like you would accept us doing the same thing. Don't explain why we're on the side of the line. Just say it's on that side of the line.
That is correct, Your Honor. We would be perfectly happy to have that decision come out. However, I offer you another path.
Yeah.
And the other path is to take the step back and say, it doesn't matter what his math was, the math is wrong from the start because of the finding that he does have. The judge got it right before he got it. The Nishad Khan had asked him, disagree with they asked for two things. They asked for Nishad Khan to be expelled as a member and that they get 100% of the proceeds of the company because Nishad had been expelled. That was the two requests. The judge denied both of those. The judge said he is a member. He is entitled to 50%, and he is still a member to this day as long as this corporate entity exists by way of this appeal. And then the judge also said, you don't get 100%, but I am going to divide it unevenly, and then came up with these numbers. This court can and should take that step back and say, well, once you reached your first decision that he was never expelled and you had no authority to expel him, and you took actions, the eviction action, the expulsion action, that were never sanctioned by a majority of the voting partners. And this is a problem whenever you have a two-person organization and you need a majority. Obviously, deadlock is really easy to get to. In 2013, when they formed this organization, there was no problem because they were working well together. By 2016, things had started to change. Mr. Elawai stopped paying his rent, started taking proceeds. And then by 2019, things had deteriorated greatly and threats were coming from one side to the other, including this expulsion. None of that, well, you can make threats, but you sure as heck can't take legal action, retain attorneys, have those attorneys sue the other partner when there's no authority of the company to do that. 2 votes were required. 2 keys had to turn to launch those missiles. There was never a second key. They argued, we don't need that second key because he's been doing bad things and he should be expelled as a matter of law. Well, the judge heard that and the judge said, no, he's not expelled. He is a partner. He is still a 50% partner. Given that, none of the math matters. None of the other findings matter. What we know is that those decisions of the one side to take unilateral action against the other side in the name of the company was ultra vires and therefore void ab initio. None of those actions should have counted or mattered, and the judge should have ruled because none of those matters mattered. There is no back rent, no minus this, minus that, and just simply if there was no sanction to be levied for the ultra vires action, at a bare minimum, it should have been divided 50-50.
So the ultra virus action, the decision to evict, the decision to defend the foreclosure, those are actions. Rent being due is not an action anyone took.
And on that, I would like to clarify that the rent being due is not Nishad Khan, partner of Nika. Rent being due is NKPL, a law firm that was a tenant. And there are, of course, great disputes between the parties on that, in that both parties originally provided rent. Both parties used large amounts of the property. That 5,100 approximately square footage was during most times used by Mr. Elawai, 6,100 by Mr. Nishad Khan, and they both were paying rents from 2013 to 2016 until Mr. Elawai wasn't paying rents, but decided that that was appropriate for reasons that have not been sufficiently illuminated for my knowledge. But regardless of who was paying what rents, if there is an action to be taken by the landlord against the tenant, that doesn't involve the partnership's structure, but it does involve the partnership to the extent that if they're going to hire an attorney and take a foreclosure action, they need to agree on that. And they did not. One side did that unilaterally, and then that side decided we're going to seek double rent, even though that's clearly a penalty provision that should only be taken under certain instances. In this case, doesn't meet those instances. But the core issue being what was allowed, what could this company do? And that's the problem with 2-person companies, because yeah, Mr. Elawai could say, well, I'm hamstrung. He's not, that company, Nishad Khan PL, isn't paying us rents. And because of that one thing, we can't survive, even though there's other things going on. And then there's COVID going on. And then you get a PPP loan from COVID and you don't put that towards the company and instead spend it on other things like attorney's fees that should have never been initiated. All of these things happen or don't happen, but they don't really matter. What matters is if you have a 2-person company and your membership agreement says both need to agree to make a majority and they don't, the company can't do it. And if the company can't do it, we've got a deadlock. Someone can go to court and say, I can't work this way anymore. This company is hopelessly deadlocked. Please dissolve us. And whether the other partner likes it or not, dissolution is what happens. That's what the dissolution statute is there for.
Counsel, can I ask you about the rent again?
Sure.
Is it your position that the only rental obligation was the was the law firm's obligation and it was never Mr. Khan's individually?
That is absolutely correct.
Is that an argument made below?
It is my understanding that it was. I can't cite you.
Can you tell me where? I couldn't find it.
Okay, I will look while my colleague is up and I'll see if I can find that record site for you.
Counsel, to follow up then, what do we make of the letter, the demand letter from the Scambus law firm? It's Exhibit A to the counterclaim. And I'm just reading it, at the bottom of record page 2218. It says, with respect to the claimed failure to pay rent, Mr. Khan's and Mr. Hawari's agreement with respect to rent is in dispute. Mr. Khan has paid rent for many months. His rent was reduced. Mr. Khan has paid Mr. Hawari's distribution in lieu of rent. It over and over again refers to Mr. Khan's payment of rent and his rent. What do we make of that? Can't we rely on that as being some kind of admission that it was his rent and the law firm's rent, or even his alone?
I would argue no, in that obviously when a person's name is associated with their firm, those are going to be used, unfortunately, in this instance, interchangeably. What matters here is the pleadings and the actual agreement itself. There is no written
agreement, though.
It's an oral agreement, and that does create the problem. Is it's an oral agreement where there's to the idea that an individual would have to pay rent as opposed to the firm that's actually using that space. It kind of doesn't make logical sense.
It could have been Mr. Khan's agreement with Mr. Hawari to let my law firm use the building. I mean, they could have made that agreement. Right?
Certainly those types of agreements could have been made. I see that I'm running low on my time and would like to reserve the rest for rebuttal. Thank you, Your Honors.
Good afternoon. May it please the court. My name is Jay Brennan with the Gray Robinson Law Firm, and I have the privilege to represent the appellees Nika LLC and Ahmed El Hawari. In the courtroom is my former law partner, Dylan Hooper, who's now with Morgan & Morgan, but he tried the case with me, so I wanted to acknowledge that he is here. We thank you for the privilege of oral argument and appreciate your service here. We submit that the controlling and overarching rules of appellate review that apply here are that the findings of fact and the equitable distribution by Judge Chu of Nika's assets should be affirmed where they're supported by substantial competent evidence, and they are here, where Judge Chu assessed the credibility and the weight of the evidence from his superior vantage point, and that Judge Chu reasonably exercised his discretion in equitably dividing the assets. Everyone agreed that Nika was to be dissolved. There was no dispute about the amount of assets at issue. The building had been sold and there were rents deposited into the court registry. So those were undisputed facts. It was approximately $1,116,000 to be divided. Each party asked for 100% of the proceeds, and the court heard the competing equities and arguments and evidence on both sides. And there were some significant credibility issues.
Counsel, can you respond to the ultra-virus argument?
Sure. The operating agreement, this was a member-managed LLC, and the operating agreement gave each of the owners authority to operate. And there's a specific provision where the owners are designated as officers, and they were here in the corporate records, each designated as manager. So in a situation where rent was not being paid by one member who had control of the flagship portion of the building, he wasn't paying rent. either one of them, but certainly my client, as a manager, had the authority to terminate this oral lease, to provide the proper notice. And that notice was given and the oral lease was terminated as of December 31 of 2019. And counsel talks about the math, and the math is, I can show it almost to the penny, but counsel downplays the specific findings of fact by Judge Chu. First, and this was a hotly contested issue, the first finding was that Con PL was a tenant of NECA pursuant to an oral lease with the obligation to pay rent or to relinquish the space if rent was not being paid. Mr. Khan argued, I'm not a tenant. There's no lease. But that evidence, the judge found that not credible because Mr. El-Hawari testified about the lease. And then we had the tax returns of Con PL, which deducted rent. We had the checks from Con PL, which had rent on the memo line. So Judge Chu's finding that there was a lease and an obligation to pay rent, and then an obligation to give up that space if rent was not being paid. And it went unpaid for two and a half years. And the way this business was structured, rent was the source of income. There were no provision for mandatory capital calls. So without the payment of rent, we get to Judge Chu's next finding that Attorney Khan was the owner of Con PL. He had control over its affairs. Con PL, next finding by Judge Chu, Con PL was not paying rent and was refusing to relinquish the space, the flagship portion. They were the anchor tenant for this building, and they wouldn't pay rent or give up the space. And then this is,
Ask you to move to
Sure.
the attorney's fees, because I have questions about it, so I just want to make sure we get through it. The attorney's fees provision says that a member could recover, any fees they incur on account of any breach by the other member, of the LLC. And, I looked at all the various versions of the complaints and the supplemental complaints, and I didn't see any claims for breach of the operating agreement. And I looked at the trial court's order. There's some findings in there that paint them in a bad light. I don't see any findings that anybody breached the operating agreement.
here's where that was, Your Honor, and I believe Judge Sandor, who entered the order awarding attorney fees, found that there was an entitlement to fees based upon Judge Chu's findings. And I'll just mention one more of Judge Chu's findings, that the failure to pay rent or relinquish possession for 2.5 years, that created the financial solvency
I
issue.
get it. No, I know, I read all those findings.
So
I didn't see any of those findings that said, and that breached the operating agreement.
all right, so then let me get to that directly. Paragraph 18.11 of the operating agreement is a broad indemnity provision, which comes to Your Honor's point that any damages, expenses, attorney fees are recoverable, where there is a breach of the operating agreement by a member. Mr. Khan is the member. Paragraph 18.07 of the agreement states that the agreement is governed by Florida law.
I saw that in your brief, counsel, and I'm not seeing how a choice of law provision saying that the agreement is interpreted, the provisions in the agreement is interpreted according to Florida law, means that Florida statutes are incorporated into the agreement such that if you breach them, it now becomes a breach of the agreement. It's not like that choice of law provision mentioned the LLC Act. I mean, did it incorporate every Florida statute? They breached some other random Florida statute? Is that, if they had breached some security statute,
No.
is that a breach of the operating agreement?
And we're not arguing for that, but what we are arguing for, and this is specifically incorporated into the contract, both by the contract provision and by Chapter 605. under section 605.0491, the duty of loyalty and the duty of care are specifically incorporated into the operating agreement by Florida law, unless that's modified, which it was not in this agreement.
Can you give me that statute number again?
Sure, 605.0491. And the duty of loyalty governs conflict of interest situations. So we had a situation where one member is leasing.
Which subsection incorporates this into operating agreements?
Your Honor, I would refer you back to section 605.0105, which is at the beginning of chapter 605. It deals with the
0105.
yes. And it prohibits the company from eliminating the duty of loyalty and the duty of care.
So saying you can't eliminate a statutory duty in an operating agreement is different than saying that statutory duty is incorporated into the operating agreement. Which provision, I want a subsection number, right? Give me the language you're talking about that says this statute or any part of the LLC Act is incorporated into the operating agreement.
Here's what I would say, Your Honor. The operating agreement states that it's governed by Florida law. Chapter 605 applies to all limited liability companies in Florida law. 605.0105 tells us what an operating agreement can or cannot do. And what's most important to this case is 605.0105 states that the operating agreement cannot eliminate the duty of loyalty or the duty of
But
care.
Counsel, I appreciate that. I understand what you're saying. Is there any provision that says that the 605.0105 or any other part of the LLC Act is incorporated into the operating? I understand the operating agreement can't waive them. Statute says that. That is different than saying it is part of the statute is part of the operating agreement. Is there any provision that says the LLC Act or any provision of the LLC Act is incorporated into the operating? Is that a,
Yes,
if there is a provision, please give me the number.
I believe there is, Your Honor. I did not bring the entire statute with me. And so I can't cite it to you chapter and verse, but I believe that chapter 605 governs all limited liability companies in Florida and is part of an operating agreement.
I didn't see anywhere in your brief where you cited a provision. I looked at all the provisions you
Yeah.
cited, but then I get your argument. That's what you laid out in your brief. I didn't see anything in your brief, and you're telling me you can't come up with now any provision of the LLC Act that says the LLC Act is incorporated into an operating agreement. I understand certain parts of the LLC Act can't be waived by an operating agreement, right? That they can govern an operating agreement. Obviously, the operating agreements can be subject to statutes. But I didn't see anything you cited in your brief, and you're telling me now you can't come up with any provision that says the LLC Act is incorporated into the operating agreement.
Just right now, I believe I can, but I can't here at the podium, and I apologize for that, Your Honor. But if we look at 605.0491, if the duty of loyalty and the duty of care cannot be eliminated by law, then I believe under an earlier section of 605, which describes the scope of the act, that those duties are incorporated into every LLC operating agreement in Florida. And these duties that we contend were part of the contract and were breached by the actions in
So
conflict.
is your argument there dependent on your belief that there is some provision that incorporates them and you just can't come up with it now?
Yes, sure.
Okay. So if.
And I apologize for not.
That's fine, you know, we're not perfect, I'm not upset about that. But if you're wrong about that, because I did look at all the provisions in your brief and none of them said that. So if it is something you're gonna cite to us, I don't think you cited it in your brief. If you're wrong about that and there's no provision that says that, does that mean you lose the attorney's fee issue?
On that point, certainly on our citation to, section 605.0491. But I believe those sections are incorporated. The operating agreement, itself, would require, good faith, fair dealing, no conflict,
I mean,
of
there's
interest.
lots of the operating agreement, I just didn't see any finding that it was breached.
Well, and let me go back to Judge Chu's findings. He found that under the control of the member's law firm did not pay rent and did not relinquish possession.
Is there a paragraph you could point to where Judge Chu said, this action breached the operating agreement?
He did not say that explicitly. But I believe that's a fair conclusion from his findings that there was a tenancy which was disputed. He resolved the credibility issue there. There was a lease, the lease was breached, space was not returned for 2.5 years. That's what created the financial solvency issue. That's what led to the mortgage foreclosure. And that's what required the attorney fees that were incurred in the eviction and in the defense of the foreclosure proceeding. And in that defense, we recovered the very proceeds that we're arguing about today. In defense of NECA, we were able to persuade Regions Bank not to accept default rate interest. Very, very rare. And to agree to a private auction sale versus a courthouse step sale where there would have been no equity realized. And Mr. El Hawari testified about that, how we were able to accomplish that. But then getting to the point of the math, the proceeds at issue, $1,116,000. The credits that my client requested, because Judge Chu made some preliminary rulings. He ruled that Mr. Khan was not expelled and remained at 50% owner. But then he ruled on the tenancy issue that Khan PL was a tenant. And then he made further findings. But so once he ruled there were 50-50 owners, we then, all parties agreed that the company should be dissolved. All parties agreed that the proceeds should be equitably divided. The appellants argued for 100% on their side. Both sides argued for 100%. But my client, we argued for specific credits. We argued for a credit toward the unpaid rent. The unpaid rent was $500,000. Since there were 50-50 owners, we argued for a credit of $250,000 with regard to the rent, including holdover. There was no dispute. My client had paid the 2018 and 2019 real estate taxes, which was about $86,500. We asked for a $43,000 credit for the real estate taxes. And then we asked for the attorney fees in the eviction and the mortgage foreclosure defense, which Judge Chu found that litigation, that expense was necessary to protect and to create the asset that we're here arguing over. That was 50,000. So the total credits we requested was 343,000. Judge Chu essentially awarded us 308,000. And actually, in our part of the proceeds, there was 32,000 that had been deposited as rents in the registry of the court. And in my closing argument, I said to the court, if you give us the rent credit that we're requesting, then that $32,000 should go back to Mr. Khan or Khan PL, who deposited those rents. And so if you take the 343,000 in credits that we asked for and subtract the approximate $33,000 in rents that we said should go back, then the numbers are almost exact in that Judge Chu gave credits to Mr. El Houari based on rents, real estate taxes, and attorney fees of approximately 310,000. Now, the other side argued that the judge should give them credit for tenant improvements in their space. But their own experts said that tenant improvements are depreciated. We looked at the ConPL tax returns. Tenant improvements are not rent. Those are capital expenses that are depreciated. In contrast, the rents on the ConPL tax returns, they were showed as being paid and they were showed as deductions against income. And then the 2019, 2020, 2021 tax returns showed no rent. That was the 2.5 years of unpaid rent that the judge got it right in crediting that. Thank you.
May it please the court. I want to first go to the point that is at the end of the briefing, and that is the attorney's fee issue. The attorney's fee issue is not the issue that we're hoping to prevail on, but it is absolutely an issue that we must prevail on if the other issue is not to be reversed. American rule must hold. You must have a contract or a statute in order to empower a shift in fees. It's not enough to have a vague duty of care, duty of candor, duty of all of the good things that people can and should do.
Just, did I miss in the brief? I know opposing counsel, you could come up with that. I'm sure you read the brief very closely.
Yes.
You got duty candor to court. Did I miss anything?
You did not, Your Honor. And I believe in our reply brief, we specifically mentioned the fact that most of our arguments in that regard simply went unresponded to.
You're not aware of any provision of 605 that incorporates the statute into the operating agreement?
I am not so aware, Your Honor. So that being the case, we are still hopeful, however, that this court goes beyond a reversal on the issue of fees to reach the merits of the underlying judgment. That we just heard well, it was close. If you take our number and you pick this one thing that might have adjusted it, it gets close. It still doesn't match. We still don't get an exact fit. And if we don't get an exact fit, where are these numbers coming from? And a really important part of those numbers is no matter how you do it, no matter which version of that you do, you would have to agree that this concept of holdover rent was permissible and El Houari was correct to double charge Nishad as a penalty for holding over. And the problem with that is that, one, a penalty provision should not have applied in an ultra vires situation where there are clear disputes on who's in control here and who's got the authority to do what. But secondly, if you are going to do it, even the case that they filed with this court yesterday, and this court's aware that that's not the practice that this court would like to see. But even if you take that case says upon proper notice, those provisions.
All the notices found invalid?
The 2019 ones were.
The August one, right?
Correct. Both the one that they attempted in 2019 was deemed invalid, which is why they amended their complaint. We believe the proper should have been dismissal of the complaint and refiling. But that regardless, because we would have gotten to the same point anyway. But when does that clock start on the double rent? It does not start when you have improper
You
notice.
see, it might have started in August.
Right, in August of 2020.
Yeah.
Yeah, we would concede that if this court believes that an oral lease that does not have a definition of when the lease ends is susceptible to holdover rent, and if this court allows for the eviction to be proper in this ultra virus instance where there was an objection, in those instances, then yes, Your Honor, it would start in August of 2020. And that's a significant amount of money. We're talking, $8,000 plus a month, every month between, that date in 2019 and the much later date in 2020, we're talking $100,000. And that's not chump change. That's something that matters. It's material and worthy of this court's reversal, even on just that point. We believe that if this court is going to look at the late filed case, that dissent really does a nice job of explaining why it is that we don't do that. And interestingly, in the 23 years since that case was decided, only one court in Florida has ever cited it. And that court didn't cite it for the purpose of the holdover provisions, just for the oral lease concepts. So for all of the reasons that we've got in our brief, all of the reasons that we've explained here, and for the interest of justice and equity, appellants Nishad Khan and Nishad Khan Law respectfully request this court to reverse and remand to either provide the 50% split or open up for findings that are consistent with law, or at a minimum to reverse for attorney's fees. Thank you.
I want to thank both counsel today for their time and argument. We are adjourned.